Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning.
Morning.
We are happy to have you with us here in Richmond live. And we look forward to hearing from you. We're happy to hear argument in our first case, number 20-1630, 1988 Trust for the Allen Children versus Banner Life Insurance Company. Mr. Sloan.
Thank you, Your Honor. May it please the court. Jevin Sloan for the appellant, the 1998 Trust for the Allen Children, and I too am happy to be here live once again. In 1991, this court held in NRA Jiffy Lube Securities that the primary concern addressed by the requirement that a class action settlement be approved by a district court is the protection of class members whose rights may not have been given adequate consideration during the settlement negotiations. This illustrates the primary issue that we raised in our objection and now in this appeal from the district court's final approval of the settlement in this case and overruling of our objection. The appellant is a trust that technically fits within the settlement class definition in this class, but that has a different claim and a different injury that was not encompassed within the allegations in the Dickman complaint. Nonetheless, the overbroad release in this settlement purports on its face to extinguish these distinct and separate claims. And in fact, the defendant Banner has admitted that one of the purposes of this release language was to do just that, to extinguish the claims relating to what we call in our objection deficit account harm belonging to the Allen Trust and other class members. The two primary questions on this appeal, both of which we believe the district court answered improperly, are first, do the Dickman plaintiffs have the same interest, claims, and injury as the Allen Trust and other similarly situated class members, such that these claims related to deficit account harm can properly be settled and equally broadened on that basis alone, reversed?
Does your client also have a cost of insurance harm, as you term it? I thought they had about $36,000 or so in the account when the cost of insurance rate increased. Do you have both harms, or is your argument on the facts that you only have the deficit account harm, the negative account?
Well, Judge Rushing, we have not been able to explore that fully in discovery, but that is certainly the reason we are told we're part of this class. It has been represented to us by both Banner and by the Dickman plaintiffs that in 2015, that's the class. In 2015, we were subject to a COI rate increase. And Your Honor is correct that during that time period, our positive account value was reduced to zero. So in that respect, we might have the COI harm that they're talking about. The problem is we have alleged and we have discovered something much different. And that is, and we can move right to that, which is the answer to the first question. A class action settlement is clear under Fourth Circuit precedent, Berry versus Schulman. A class action settlement can only release those claims that are based on the, quote, identical factual predicate as the claims underlying the settled action. So the first step is, what was alleged in Dickman? What is the factual predicate of this case? As Judge Rushing pointed out, it's COI harm. So let's talk about what that is. The Dickman plaintiffs purchased universal life insurance policies and paid excess premiums to accumulate a positive cash value. Dickman alleges that they did this based on certain representations from Banner about the financial condition and stability of the company. They relied on those representations. In reality, Dickman alleges Banner was actually in dire financial condition and needed cash. So to obtain this cash, Banner rated the positive cash value that these particular class members had accumulated through the payment of excess premiums. The Dickman case is centered around Banner obtaining essentially a capital infusion by clawing back actual cash from positive account values of policyholders who paid excess premiums. How do we know this? If you look at the complaint, paragraphs 24 through 28 of the Dickman complaint, They explained that each of the plaintiffs paid excess premiums to accumulate a positive cash value. Shortly thereafter, paragraphs 30 through 31, they alleged that Banner in turn rated that positive cash value by taking cash back. Paragraph 202, Banner is the quote, Banner is paying itself the increased COI charges by taking money from the policy's accumulated cash values. And paragraph 206, Banner's conduct was intended to have plaintiffs, quote, pay excess premiums and build the policy's cash value.
Is there a difference between the deficient account harm and negative account values?
Your Honor, the deficit account harm is a negative account value. And that is something that the district court latched onto and thought that that was pivotal. We've never disputed that deficit account harm was negative account value. We define it as such. The problem the district court made is that it said, well, deficit account harm is nothing more than negative account value. And the Dickman case dealt with negative account value. Here's how we know that that cannot be reconciled with the allegations in Dickman. If you look at the real theory of the case, what did the Dickman plaintiffs say was the reason Banner did this? Paragraph 9 of their complaint. Banner to find new cash. That's a quote.
I thought it was also to get them to relinquish their accounts. Wasn't that one of the allegations?
The other one was to rid itself of near-term liabilities. Another way to raise cash, save cash in the short term. It was either to find new cash or to get policyholders to surrender policies to avoid near-term, quickly appreciating liabilities. Same allegation at paragraph 236. That is the why. That is the reason why the Dickman plaintiffs said that Banner did what they did. Deficit account harm, these negative account values, is entirely different. We did not pay excess premiums. We did not build up a positive cash value through excess premiums. We did have a positive cash value for a little while from our minimum level premiums, but we did not pay excess premiums. Rather, we paid the level minimum premium required under the policies to make sure that policy stayed in force for the full guarantee period. And we did this relying on disclosures within the policy documents that allowed us to reasonably predict what we would have to pay in year 21 to extend the policy. Now, Banner says when we chose to pay level premiums, we converted this to a term policy. That's not true at all. We knew there would be more money due in year 21. We believed that we would be able to reasonably predict that based on the maximum COI rate allowed in the policy documents. What we found out in 2018, solely because we were trying to pursue a life settlement of this policy, we found out for the first time that despite Banner sending us account statements month after month, showing that we had a zero or more cash value, never a negative account value. Despite that fact, Banner was secretly accumulating a negative account value, a deficit account, that it intended to then charge us as a catch-up premium in year 21. Prior to finding that out through our exploration of a life settlement sale, there was we had no idea that there was a negative account value building below the surface.
Well, the district court seemed to think that your damages were speculative. I mean, that was the whole problem, I think, that he thought with what you were saying. And if you just look at the contract as you so far have discussed it, your clients do not suffer any financial harm until what? They're 95?
Well, 96 would be when the year 21 premium would be due, Your Honor.
Yes. And so what do you have to say to that?
Well, that's certainly a position that the Dickman parties took, and that's a position that the district court agreed. We obviously disagree.
Why is that wrong?
It's wrong because we actually articulated 3 different damage models in response to our interrogatories that were served on us. One was, in fact, the present value of this deficit account harm.
This is if you wanted to sell it.
No, Your Honor. This is a deficit account harm that was accruing that we would have to pay in year 21 if we extended the policy.
Yeah, but that isn't a damage as of this moment.
Well, Your Honor, we have cited cases that even future damages, when they can be reasonably anticipated and there's a solid basis for them. Even future damages would not be speculative.
You said you had 3 bases.
Yes, Your Honor. The second one is the actual premiums that were paid. It's our position by Banner doing what they did, they sold us, they purported to sell us a universal life policy, a permanent life insurance product, but instead they just sold us really a term policy. We didn't get what we paid for. And so a refund or disgorgement of those premiums would be a remedy as well. It's notable that Banner and the Dickman plaintiffs take the position that refunding premiums is appropriate for the people who suffered this COI harm, the reduction of their positive cash values, but for some reason it's not an appropriate damage for these class members like the Allen Trust.
Well, you understand the difference. You got the coverage, right? You paid for the coverage you got. The question is what happens at the end?
Well, we did not get what we paid for, Your Honor. We did not pay for a term product. We paid for a universal life policy that we believed, based on everything that was told us, could be extended through as a permanent life insurance product. So yes, we did get a term policy, but that's not what we bought, and that's not what we paid for. And of course, the third element is the reduction in value, which is illustrated by the fact that we could not, this is a worthless policy in the life settlement market.
I thought you had some sort of, maybe it was from an expert, an estimate of what you should be able to get for this, or
we did have an estimate of what we had valued it at, and what it would have been valued at if it had been handled correctly, if there was no deficit account. And so that would be the measure of that damage, because now we can't get anything. And I believe it was somewhere, it's in the record, I believe it was somewhere south of $300,000 is what that particular damage for that class member is. The district court didn't analyze those 2 other elements of damage. And we also believe that even as to the first element of damage, the analysis was incorrect. But again, these are going to the merits of the Allen Trust deficit account harm. We don't believe that is an appropriate analysis for the Dickman plaintiffs or the defendants to have done, because it does not fall within their case. Deficit account harm has nothing to do with excess premiums. It has nothing to do with positive cash value that Banner could then claw back to raise cash. And that's, of course, the very important part I raised with Judge Floyd, is that was a key holding by the district court, that Banner has to do with negative cash value. The entire theory of Dickman is that Banner did this to find new cash or to cause policyholders to surrender their policies in the short term. Secretly driving an account into a negative hole without the policyholder knowing does not in any way bring in cash for Banner, nor could it cause a policyholder to surrender their policy in the short term. There is simply no construction of the Dickman complaint and their theory of liability that the Dickman plaintiffs have set out that can encompass this deficit harm. The problem is we don't have the common answers required for commonality. We don't have the aligned interests required for typicality, and we don't have the same injury required for adequacy. As this court put it in the Sharp Farms case, 917 F3D 276, pinpoint side of 280, we have the same problem as Sharp Farms. We have divergent legal theories, and we have a fundamentally different interest in a different injury. And if we move on quickly, I see I'm down to 2 minutes. If we can move on to the fairness inquiry under 23E, even if it is these claims were properly included within the release, the 23E analysis fails as well. That is the analysis of, was this fair to class members like the Allen Trust? And we say no. It's undisputed that the damages that were negotiated during the settlement didn't include any of this deficit account harm or account values that we describe in our complaint. Banner has admitted they never even compiled the data for the plaintiffs to make such a calculation. It was never considered.
Can I ask you, how is the class formed?
I'm sorry, Your Honor.
Was it advertised? How is the class formed?
I'm sorry, I don't. Could you rephrase your question, Your Honor? I'm sorry.
Yes. The people that are in the class, how did the lawyers find them? Is I guess what I'm asking you.
Your Honor, I don't know that because it wasn't my class. I don't know how.
Okay, what about your class?
They reached out. They came to us. The Allen Trust came to us.
Is it only the Allen Trust? Are there other people?
The Allen Trust is the only trust we represent, But based on what happened here, we believe there are other people, and that's the point of our objection. And it's a situation that this court actually pointed out the Second Circuit pointed out in National Super Spuds. When you have a situation like this, where there's one objector, it doesn't have as much of an impact on the analysis when the point of the objection, this is a quote, is limited to a few whose interests are being sacrificed for the benefit of the majority. And this is the important part. It means even less when, as here, the notice of settlement did not adequately apprise class members who also held claims in respect on unliquidated contract that these two were being placed on the block, although these class members were to receive nothing in return. Nothing in the complaint, nothing in the settlement agreement, nothing in the class notice put any of the class members on notice that they had these actual negative account values and they were being forced to release them with no compensation whatsoever. Your Honor, I see my time is up. Unless the panel has any questions, I will sit.
Thank you very much.
Thank you.
That is certain substance of the debt and debt. Problem occurred when Allen filed this case in California. Banner went to California and made arguments or assertions that Allen really involved COI. Allen rejects that premise and has opposed that. No one has asked Allen to this day if they can see that any of the claims in their lawsuit would be released if this settlement is affirmed. Allen steadfastly claims that none of their claims or causes of action are predicated upon the COI increase. If that is the case, the release that they are concerned about does not purport to bar any of their claims.
Can I ask you a more fundamental question?
Yes.
Because it troubled me. Did the district court abuse its discretion in the way it certified the settlement? You know, we usually think when you go look at a class action, there's certain factors you look to. And I know you say that some of them the other side waived, but in fact, they didn't. I mean, I found the argument in the JA.
Well, in terms of the 23A requirements,
Yes.
the district court may find its own appropriate record at preliminary approval stage that the requirements of 23A and then 23B3 were met.
You would concede that the district court has to make those kinds of findings.
Correct.
And it has to abide by what the rule says. Because the district court seemed to think that your proficiency as a lawyer, and I'm sure that that's true, sort of erased every other concern.
I don't, with all due respect, I don't know that I would agree with that statement, Your Honor.
Well, the district court says there's no problem with this because we all know that we have great lawyers on either side.
Well,
And then doesn't do numerosity, commonality, typicality,
well,
and thinks adequacy of representation deals with the quality of the lawyers. And that may be part of it, but another part of it is whether you represent all of the people in the class.
we represent all the people that were impacted or could have been impacted by the COI increase that we set with the district court on the preliminary approval, Joint Appendix 738, page 4, and then the final approval, Joint Appendix 2899, paragraph 7, made reference to the his findings from the preliminary injunction, I'm sorry, preliminary approval stage to the final hearing. But we made a record of numerosity, commonality, typicality, adequacy.
Okay, so you tell me where you think those findings are?
Those
The
findings,
district, not your argument, the district court's findings.
I believe the findings are joint appendix 738, page 4, which was preliminary approval.
One page? It's a lot of findings for one page.
Summarized. So yeah, I think that's what the district court did on the record and then entered the order. And then on the final approval stage, 2899, paragraph 7.
Well, Mr. Sir, where in that order did the district court, either oral or written order, where did he ever compare the claims between the Allen Trust and the Dickman Trust, Dickman representatives? Where did you do that comparison?
In the transcript, Your Honor, he made detailed findings regarding what deficit account harm was, that it was in fact negative account value, and the negative account value had been taken into consideration as part of the settlement negotiations and the overall relief.
Did he put that in a written order that we can see?
I believe it's only in the transcript. I have to go back and double check. I don't want to tell people something's not. But in final approval order that came after his findings and his ruling on the record, I'm not sure that he discussed in detail what he did on the record.
Well, do you agree or disagree that the claims of the Allen Trust are in fact different from the Dickinson folks?
They claim that are different. One of the things that
Well, okay, they claim it. So how is it, from your position, that they aren't different?
if their claims are not based upon, some or all of their claims are not based upon the COI increase, and their claims are distinct, and the release does not purport to release those claims. For instance, Allen claims, in essence, a fraud in the inducement, that they thought they were buying a permanent life insurance product and received a term product. That has nothing to do with COI. And leaving aside whether that claim is meritorious or not, that claim is not in the Dickman case, and the release doesn't purport to release that type of claim because it is untethered to COI. It doesn't arise from the same factual predicate. And one of the reasons.
I'm sorry, I thought in response to Judge Rushing's question that your colleague on the other side said that in fact, some of this money that they're claiming might be or was COA money. That's my first question to you. And the second one is, well, if it seems to me that what you're saying is if it is COA money, it's covered by this settlement. And if it's not, it's a different case and they should go forward. Is that what you're saying?
That's correct. If it is not COI related, if the claims in Allen do not arise from the COI cost of insurance increase that occurred in 2015,
But
then the release on its face does not purport to release those claims.
I took from what he said that you have a situation here where some of their claim is tied to the COI and some is not. So that would sort of defeat your argument, or damned if you do and damned if you don't. But they're saying they have both.
Banner says that it is. Allen says it is not. That factual dispute and the record be created on a motion is in the Allen case, which we are not in. And that is how this got hijacked and down a rabbit trail. the settlement's unfair. Township Court Allen has made it clear on the record, but for the issue of the release, they have no problem with the settlement, and none of the other almost 11,000 policyholders had a problem whatsoever with the settlement. It is fair, it is reasonable, and it was done at arm's length over a 6-month protracted mediation
Well,
process.
but having said all that, you can understand if the release releases their claims, even though the settlement is fair and appropriate, negotiated over at arm's length over a long period of time, that they have a claim. You may not think it's worthwhile, but it's not, it's not as if they came in from the blue.
But as you've seen in a number of the cases that are cited, there are instances where you're in a class, have certain claims in a class that are being surrendered in exchange for consideration, and you have other claims that are completely unrelated, and those claims are preserved. Here, Allen is in this class as it relates to the policy and a COI increase, and they're going to receive relief. For the COI claims, the release doesn't purport to release anything other than COI claims of the same factual predicate.
Okay, I think your time has expired. Your colleague is anxious.
Tim O'Driscoll for defendants Applebee's Banner Life Insurance Company. Want to go directly to questions of record in this case. It was a textbook record. Everything appropriately. How do they not do everything appropriately? I want to Your Honor, as for the analysis, the judge's analysis. That analysis was at 720, 725. It was also in the order that the judge read and signed 741, 740. The second Ferris judge noted that there are many points how he apparently read all the submissions and gone through all the discovery. In terms of his findings, the judge addressed all of the Rule 23 factors, including 23 factors again. Appendix 2847 through 2850. The judge gave his 23E ruling on the record at Joint Appendix 2861 through 2867. The judge also, in the final approval, he incorporated the preliminary approval order findings at 2902 appendix and addressed the Rule 23E factors at 2904 through 2905. Judge Bennett also said in that order that the court had allowed for limited discovery to determine if any of the claims brought by the Allen Trust in a separate lawsuit were subsumed within this matter, and if so, they were fairly and adequately compensated, etc. Which the judge found that they were subsumed and they were fairly and adequately compensated because they were totally speculative. That was at specifically 2865 and 2867 of the Joint Appendix. There was no clear use of discretion at all. In fact, his findings were totally correct. I could go, by Your Honor, now to the complaint. The complaint must be said, emphasized, broadly encompass increased COI charges. It's not limited to positive account value or excess premiums, as the Allen Trust has said. The Allen Trust cherry picks certain paragraphs from the complaint that were on aspects of the fraud claim that involved excess premiums. It's very clear from the record. I will point Your Honors to the record. This is the complaint, pages 107 to 114 of the Joint Appendix. The heart of the dictum complaint, paragraphs 224 through 234, alleging that as to each product type, that Banner was not justified in increasing COI charges. Another example, page 118, joint appendix, paragraphs 248 to 249, alleging that Banner breached the contracts by violating its duty to determine the correct monthly deduction of the CO's account and to refrain from increasing COI except under very specific conditions. Final one I will point to, depending more, is pages 120 to 121 of the appendix. Number of paragraphs alleging that Banner was unjustly enriched by payment of premiums and excess premiums. It's not limited to excess premiums. We know what we litigated for almost 4 years before the Allen Trust showed up. Very hotly litigated. We knew what we were doing. We knew what we were mediating. That's what was said. So that's a complaint. It's appropriate to compare the complaint to the release. The release is impeccable. It complied. It exactly tracks the allegations of the different complaint, and it is in full accordance with Fourth Circuit law, expressly limited the release to based on the same factual predicate.
Where and when will it be sorted out which claims that the Allen Trust brings are covered by the release or not covered? I know there's the California litigation, and I don't recall offhand if that was transferred or if that's just stayed while this is happening. And at some point, another judge is going to determine whether claims that they want to press are covered by the release or not.
That's correct. The California case was transferred.
Okay.
To District of Maryland.
So Judge Bennett will be the one who
Judge
decides.
Bennett will be deciding, but that assumes that this release is necessarily going to go forward. There are many issues with the Allen standing.
Right. You might have other arguments.
But I'm assuming the release is whatever the arguments that are made. Judge Bennett will address that in the case. And the Allen Trust admits in its reply where it says that this is not the place to resolve whether merits of claims of the Allen. So it's almost hard to hear that. I want to go to the negative account. The judge Bennett very careful to find this. He went over backwards without discovery. He ordered a supplemental briefing to determine. He knew exactly what he was doing. He said that the first final proof fully understood the Allen Trust argument. This is a joint appendix 1744. He said, I'm allowing discovery to determine the extent to which you, the Allen Trust, indicate there are other damages that may or may not be present. And I'm interested in having some clarification as to whether or not there's a distinction between the cost of insurance increases and whether or not they're intertwined with what we call the deficit account. And they are. The evidence is uncontroverted that the increased COI charges, that deficit account harm is the same as negative account value. The negative account value is comprised of unpaid COI charges. Banner submitted 2 sworn actuarial declarations in the California proceeding, Joint Appendix 880 and 1306, saying that the negative account value was directly related to the increase in COI rates and caused by. Then, in the Dickman proceeding, additional discovery ordered by Judge Bennett in March of 2020, Banner served a verified interrogatory response. This is at 2931 of the Joint Appendix, saying that the potential future negative account value in year 1 is comprised of unpaid COI charges. Also, for the sake of completeness, a parenthetical reference there is made to expense charges, which are a tiny fraction of 1%.
So help me here. I think I'd understood that they covered the same subject matter, but I thought it was sort of at different times. The negative account value is what they're valuing. They're saying that the account is less because of these things. And the deficit account harm is what relates from that, what that factor is. Do you understand what I'm saying?
I think so, Your Honor. That's
Good.
Deficit account harm was a term that's made up by the Allen Trust. The Allen Trust now says that it always said that negative account value is the same as deficit account harm. That's not the case. But even now, everyone agrees deficit account harm is the crux of it, as is pointed out, as is determined by the Allen Trust, is negative account value. And the evidence is uncontroverted that negative account value, as I just set forth, is comprised of COI charges The Allen Trust told witness that it insisted on putting forward the final fairness hearing. Mr. Mount admitted the negative account value is comprised of one ACOI chart. That's his deposition transcript at 2642 and 2643 of the joint appendix. And he admitted that those unpaid COI charges were fully disclosed on the annual statements.
Mr. Driscoll, is it possible that or could the Allen Trust get a cash payout on their policy?
Well, it's interesting. The point that was raised, that was the trust that has a deficit account. That's the negative
Well,
account.
I mean, the question is, can they get a cash
It's
payout?
interesting. Was raised by the Allen Trust a moment ago in terms of the amended interrogatory response about the sale of the policy. There's the interrogatory. It's in 2123.
My question is very simple.
Yes.
Can they get a cash payout on their policy?
Oh, to surrender the policy.
Yes.
They can, yeah, to surrender the policy, sir.
Can they get cash?
Yes, I believe so.
Well, let's assume that they can't. Then how would the Dickman representatives be adequate in this case?
Because the negative account value, this is a very critical point. Negative account value is totally speculative because they have never paid any of it. This is a policy benefit. It's a feature of the policy. It's described as a special grace period. The negative account value keeps the policy in force. The Allen Trust never has to pay it, and it doesn't have to pay it, never will have to pay it. If the policyholder dies within the next 2 years, we'll get $4 million.
What if the policy holder dies at 102?
Well, even then, Your Honor, this is very important too. And Judge Bennett had all this information of record. In order to get to the point of the end of the guarantee period, the policyholder needs to continue to pay the minimum premium and needs to decide at the end of the guarantee period, that it wants to keep the policy in force. And this trustee admitted at her deposition that they don't even need a policy right now. They haven't needed it for several years because it was taken out in order to pay that tax. The state plan.
Well, there's quite a difference between, I understand with rich people, between needing money and wanting money. And if the money's theirs, I dare say they want it, even if they don't need it.
Well, but the ultimate point, Your Honor, is that it's totally speculative at this time whether they ever would decide to take out the.
Can they sell their insurance policy on the market? Does it have any value?
Well, according to the amended interrogatory responses I read at 2123, they place a value somehow based on certain speculative assumptions of $321. So I don't know how they arrived at that. I don't know how the trustee verified that interrogatory. I don't know how she did that since according to the Allen Trust, she didn't know anything about insurance. But
Well, did you have some sort of expert come in and say that it wasn't that?
sorry.
Do we have any contrary evidence in the record about the value of their policies on the market?
The value of the policy that the Allen Trust said itself
Yes,
is $321,000 according to this formula. So it's
right. So you're conceding that you say that's its value. Is that what you're saying?
Well, no, I'm not conceding that's the value, but I'm saying that the Allen Trust says that's the value. It's not worth this. That's true.
But can they sell it for that? Will anybody give them that? Do you have any evidence that anybody would pay that for it?
The Allen Trust, if it's going to make this assertion, it would be the one that needs to say whether it's try to sell the policy, and if so, if there are any damages, that is a difference between what the policy would have been worth under some other set of assumptions versus what the policy is currently worth now. And they've not done that. All they've said is that according to this amended interrogatory response, formula based on certain assumptions for what a policy is worth, they say $321,000. That's not worthless. That's a value. That's a value.
But they say they would not be able to sell it. It's worth that, but they wouldn't be able to sell it.
There's no
And
evidence.
well, but they don't have to produce that evidence. You have to produce the evidence.
Well, in terms of their objection, I think they would need to produce the evidence.
They say it's worth 321. I think they're representations, but I'll ask your colleague on the other side that they have tried to sell it and they have not been able to.
There's no evidence that they received any offers or for the policy.
Well, if they didn't receive any offers, then they haven't been able to sell it, if they tried to sell it.
Well, I think, Your Honor, that the evidence has been, it's a couple. The evidence that has been introduced is that $312,000, according to this formula, would be the value of the policy. There's no indication that's less or different than sell the policy for circumstances or different. And I do believe they're going to claim damage. And certainly that's part of their burden.
Okay, for a moment, assume with me that they have some evidence. Somebody said something in an affidavit or somewhere that they were not able to sell it for that price. Would that be damages?
No, Your Honor, I don't believe that that's not the case, but I do not believe that.
Why not?
Well, because they have had insurance for this entire time, it's 18 years. Guaranteed minimum premium, taken advantage of this policy benefit so that they would not have to pay the increased COI charges. Now they're going to have, well, at this point, there are unpaid COI charges that were fully exposed to them from all the annual statements that they've seen, and they have those unpaid COI charges. They have paid, and it's totally speculative as to whether they would be able to pay. They can join policy benefit.
And this should mean that they aren't entitled to sell it? I don't really understand that. I would think you would be ecstatic to have them sell it and repay the COI charges.
Well, the point is, from my perspective, they have gotten valuable benefit from this policy. They speculative as to whether policy is worth less.
Does the policy say this is a policy in which you cannot sell on the open market? You don't have that right.
Well, no, Your Honor, and I'm not saying that they couldn't sell, but if they're going to claim some kind of damage, they're going to say this. From my perspective, this is a policy benefit. Policy benefit. And guarantee minimum. They never have to pay these unpaid COI charges. The reality is that they never will. And so if they're saying, though, that these unpaid COI charges have an impact on the value of the sale, from my perspective, is they need to show that that's the case. If not, there's no evidence to show that it impacted the value. The evidence for guarantee don't have a differential. And so it's speculation as to whether there's any damage at all from that. And I think that even if you assume that they would not be able to sell it, which that is the record, and it's COI charges that you'll never pay. If you're going to enjoy the benefit this whole time, it's loss versus opposite. Excess premiums, entire life policy, and valuable insurance coverage if they decide to continue paying these minimum guarantee. Next 2 years, if the insured should live for the next 2 years, and they never will have. And if they decide that they don't want to keep the policy in force at the end of that, they don't need the policy right now, then they never will pay these. That's why the judge found that all the evidence, 2.865 to 2.867 see that I am out of time, but I was very happy to keep going.
Thank you. You have any questions? No. Thank you very much. Before you sit down, can you tell me about the asserted damages for an inability to sell the policy?
Yes, Your Honor. In fact, I had that highlighted as the first thing I was going to talk about.
Right.
If you look at, and I don't have the specific record sites, I apologize because it's just came up in the argument. If you look at the Mountain Declaration, the deposition of Bill Mountain, he explains, and we explain this in some of our other materials, exactly what happened. 2018, we were looking to sell the policy. We tried to get an illustration from Banner. They sent us one that looked a little weird. It had some weird COI charges or some weird premium charges in year 19 and year 20. And we said, no, listen, We pay the minimum level premium. Send us one that has the minimum level premium. That's when we found out for the first time there was that year 21 premium. Mr. Mountain describes in his deposition that the whole point of this was to sell the policy, and that because of this illustration with this enormous $5.8 million premium due for a $1 million death benefit, we couldn't sell it. It was worthless. The $300 and something thousand value that we put on the policy, that's our damage. So that's what we're comparing. It should be $300 and something thousand based on what the policy said would be the maximum year 21 premium due. But instead it's worth zero. We haven't been able to sell it. So there is definitely evidence in the record showing that it should be worth this much. It's now worthless because we haven't been able to sell it.
And you tried to sell it.
They absolutely tried to sell it. And that's in the Mountain deposition where he describes those efforts to sell it. And that was the whole reason for getting the illustration.
But,
Um,
sir, the other side vehemently says that if this settlement goes through, the only thing that you will be giving up is the cost of insurance issue. Any other issues you have, you still have them. Is that true?
Your Honor, it's not true, and I'll tell you why. Class counsel cannot take this neutral position. This is exactly what the Second Circuit dealt with in National Super Spuds. In that case, just like this case, there was a release that on its face purported to release certain claims. I know they say that the release isn't clear, but it is. It says claims that arise out of the same facts, and it says including but not limited to, and it describes what it's asking the court to endorse as the same facts. One of those is any misrepresentations regarding account value. Banner has gone on record as saying it was their intent in drafting this language after we had filed the Allen class action. Mind you, that's an important fact. This release language did not become public until after we filed our class action. Banner has admitted that it was released for the purpose of extinguishing these claims. This is exactly what happened in National Super Spuds. The defendant admitted it is our position that these claims that the objector has are encompassed within our settlement. In that case, class counsel said, oh, not our problem. Our class members can go fight that in another case. It's up to a New York State court to determine the res judicata effect of this settlement. Here's what the Second Circuit said. While it is true that the actual decision on this issue will rest with the New York courts, we must assume that they will interpret the settlement to mean what it says. Experienced counsel know precisely what they wanted to achieve and drafted the appropriate language to that end. On that basis, the Second Circuit said, you know what, it is this court's decision to determine whether the scope of the release is too broad. It's not up to the class members to roll the dice and figure out whether they want to be bound to a settlement that they don't even know the effect that it has. Class counsel should have resolved this. We brought this up to them well before our objection was filed. They had a choice. They could have tapped the brakes. They could have looked into this deficit account harm. They could have done lots of things. They could have made sure the class was on notice, even aware of these negative account values that would come creeping up in year 21 when Banner waived the release in their face. They didn't do any of those things. That's the reason we filed our objection. That's the reason we're here today, and that's the reason why the approval of the settlement should be reversed. Thank you, Your Honor.
Can I ask you one question?
Absolutely.
Sorry, I know you're past your time, but I know there's a little bit of talk of the adequacy of the representation, and I just wanted to ask you about your argument before us, which from what I can tell is very different from the argument you made in the district court about adequacy. Did you make any argument about this sort of fundamental conflict of interest between former policyholders and current policyholders? I read your briefing in the district court, and it was the same argument you had been making on typicality and others, that the injury is different. But that seemed to me to be a different argument than the one you're making before us about adequacy, and I wanted to give you a chance to address that.
Sure. If I understand your question correctly, the adequacy error that we've identified is what Judge Motz said, which was the adequacy analysis done by the district court was only as to the adequacy of counsel, not as to the adequacy of the class reps. The problem.
That's your argument in front of us now, that he just talked about adequacy of counsel?
Well, that's what happened, and it was an error to not even consider the adequacy of the class reps. As I described about, the theory of the case in Dickman being that Banner was trying to raise cash. So the situation you have here is the class reps in Dickman are going to receive distributions back in cash. They've surrendered their policy, so they have no interest at all in advocating for people like the Allen Trust, who have this large deficit account by virtue of paying level premiums. So that adequacy analysis was never performed at all with respect to class reps. And the whole
Right,
point—
that's what seemed to be different for me is in front of us, you're making a class reps argument about the interests that they have that conflicts with the interests that you have, but that was not in your papers below.
Your Honor, it was in our papers below with respect to the typicality and commonality. These are different factors, obviously.
You didn't have commonality in your papers at all. It was just typicality, right? And adequacy.
We had, I'm sorry, Your Honor, you're correct. We had typicality and adequacy in our papers below. We did discuss commonality during the fairness hearing on the record, but you're right, the typicality and adequacy arguments, and they're more or less, it's the same facts driving those factors, which is the distinction between these claims, the distinction between the harm and the injury and the interests. And I can't remember exactly, Your Honor, how we phrased that, but it really comes down to that same factual predicate that these are distinct injuries, distinct claims that were never encompassed or even contemplated in the Dickman allegations.
Thank you, Frank.
Thank you, Your Honor.
Thank you, all of you, for your arguments. Usually, as you may know, we come down and shake hands with lawyers, and we would like to do that, but we think probably it's not a good idea under present circumstances. But we are glad to see you face to face and not just on the screen. So that's new for us. Thank you very much again for your arguments. And we will go directly to our next case.
Court. My client was deported in 2007 based in part on a statute that the Supreme Court held unconstitutional in 2018. Following year, my client filed a motion to reconsider based on this change in law. The question before the court today is whether the Board of Immigration Appeals erred either in denying my client's request for equitable tolling or in declining to reconsider its prior decision sua sponte. Unless the court prefers otherwise, I will address the equitable tolling argument first.
Has the question of reconsider, has that issue been decided by the BIA?
Pardon me, Your Honor, has which question been decided?
Decided by the BIA?
The BIA denied my client's request for equitable tolling and therefore did not reach the merits of the motion to reconsider itself.
Was there anything, so there's something hanging out there?
Yes. And if this court was to remand and find that my client exercised the diligence necessary for equitable tolling, then on remand, we would ask it to reach the merits of the motion to reconsider.
If we agree that we have jurisdiction as to whether Williams was his property qualifies as aggravated felon, does the law of the case doctrine apply so that if we were to remand it to BIA, would be bound by our decision?
Well, I think it's actually undisputed between the parties that my client's conviction no longer qualifies as an aggravated felony, and that issue is squarely before the board. That was raised in the motion to reconsider. Now, before getting to the merits of the equitable tolling argument, I would hope to quickly address the issues on which the parties agree and or on which the court may not need to reach. The parties agree that both the deadline and numerical limitations on motions to reconsider are subject to equitable tolling, while the parties disagree over whether my client is subject to the jurisdictional bar in 1252A2C. They agree that the court may not actually need to reach that admittedly complicated question, because even if my client is subject to the jurisdictional bar, there is only one factual issue that this court would be unable to reach, and that is whether the attorney who filed the motion to reconsider in 2019 was acting pro bono. So if this court finds that whether that attorney was acting pro bono would not make any difference to its ultimate determination, then it does not need to reach the jurisdictional arguments. But for purposes of today's argument, I'm happy to assume that my client is subject to the jurisdictional bar and that his attorney was acting pro bono, even though the record shows she was not. Now, on the merits, the question before the court is very narrow. The board did not address whether my client satisfied the extraordinary circumstances component of the equitable tolling inquiry. The only basis for the board's decision was its belief that my client did not act with sufficient diligence in filing his motion after the Supreme Court issued its decision in Maya. Now, while the parties disagree over the standard of review that the court should apply to that issue, our positions may actually be closer than they appear. On page 14 of its brief, the government asked the court to review the board's decision for abuse of discretion, but, quote, with subsidiary legal conclusions reviewed de novo. And that is on court held in Guerrero La Spria, that whether an alien acted with the requisite diligence is a legal standard. And this court has held on many occasions that an agency abuses its discretion when it errs as a matter of law. So even if abuse of discretion is nominally the correct overall standard, the court should apply de novo review to the specific legal question of whether my client acted with requisite diligence. Now, yes, Your Honor.
Don't we apply abuse of discretion review to many instances where we apply a legal standard to facts? So when we review the legal standard, it's de novo, right? Whether the BIA had the correct standard in mind. Facts we review for clear error, but often we apply abuse of discretion review when the law is applied to the facts. Think like evidentiary rulings, right? In a district court. We review those for abuse of discretion, even though it may be, in fact, a question, mixed question of law and fact. Why is that not the appropriate way to think about it?
Well, I would look to this court's recent decision in Galvan, which was decided after the briefs were in, but we submitted a 28J letter on that. And that involved another mixed question that this court found for the first time it had jurisdiction to review under Galvan. And it found that because it is a mixed question, it would apply de novo review to the ultimate determination in that case of whether the alien's removal would result in exceptional and extremely unusual hardship. So that is a very similar fact-bound determination, but the court said, nonetheless, we applied de novo review. And I would also note that this court said in Rouse, its en banc decision in 2003, that it would apply de novo review to the ultimate determination of whether the ultimate diligence determination based on settled facts. With respect to the merits question, it's undisputed that the diligence required for equitable tolling is reasonable diligence, not maximum feasible diligence. And the problem with the board's decision in this case, in our view, is that it simply took an unreasonable view of what an alien in my client's position should have taken following his removal. Even though my client was deported in 2007, the board believed that he still should have been in touch either with his original attorney or that he should have sought out new counsel simply to stay abreast of changes in the law. But Your Honors, the board's reasoning not only reflects a quintessential case of hindsight bias, but is simply divorced from reality. Consulting with an attorney is not like going to the dentist or getting your oil changed. It is not something people do every 6 months as a matter of course. It is something that people only do when they have a problem that they believe an attorney is actually capable of solving. So aliens like my client, who have both exhausted their appeals and been deported from the country, generally have no need to seek out the advice of an attorney. And as we say in our briefs, and the government does not dispute, upholding the board's decision would mean that aliens who have been deported from the country would need to regularly consult with an attorney in perpetuity.
I thought the diligence inquiry was they looked at from the time of the Supreme Court's decision until your client sought legal counsel.
Your Honor, we would agree that is the correct inquiry.
They looked at the longer period, I think.
Yes, and just as a practical matter, I mean, we know now that the Supreme Court issued a decision in 2018, but there's no way an alien would be able to predict.
Right. So how are they supposed to evaluate diligence? If you say there's no reason someone who's deported thinks they have a legal problem that they need an attorney for, they don't know a Supreme Court decision's coming, how on earth do you measure diligence? Say they find out about the decision 20 years after it happened, but the moment they find out, they seek an attorney. Is that diligent?
Well, certainly in all cases, diligence must be exercised from the moment the alien discovers the new law. Otherwise, we think it's case by case. And we think as a general rule, aliens who have been deported cannot be expected to seek out legal advice.
Your rule would be from the moment they discover, and they don't have to be diligent in looking for it, they just stumble upon it.
I believe as a general matter, they do not have to be diligent in investigating. No, they only have to be diligent once they discover. Now there are
happen to find out about it.
Yes, but I think there are exceptions. And I think this court's decision in Lawrence provides a helpful counterexample. So in that case, Mr. Lawrence's case, while his case was pending at the BIA, the Supreme Court actually heard oral argument in the decision that was relevant to his case. And then the Supreme Court issued its decision, that was the Moncrief decision, just a few months after he was deported. So we think in that case, it was plainly reasonable for the board in this court to expect Mr. Lawrence to stay abreast of the law even after he was deported. But in this case, by contrast, there was no reason for my client to expect that the Supreme Court might one day issue not one, but two decisions that would fortuitously and in combination undermine the board's finding that his conviction qualified as an aggravated felony. And of course,
go back to the time when they issued it. So where do we start when we look to determine whether he was diligent or not? What time?
Sure. We think in this case that you look at the time that my client learned that he actually had a basis to file a motion with the board. So he did not know that for certain until his new attorney received the results from a FOIA request in June of 2019, where she received his entire immigration record. There's no version of PACER in the immigration administrative system. You have to file a FOIA request. And as soon as she got it, she realized, aha, there is a basis to file a motion to reconsider with the board. And exactly 30 days later, that motion to reconsider was filed.
Well, do you have a fallback position?
A fallback position on equitable tolling?
On when the period for equitable tolling would begin. For example, I thought that perhaps you were arguing that the date when Sessions came out was versus DeMaio was 2018 and Johnson was 2010. And so that you needed both. So you would start with the 2018 date and you filed in 2019.
Yes,
It's
well,
about, I don't know, 8 months.
sure, but I think the ultimate question is what is reasonable to expect of an alien in my client's position? And given all these circumstances in this case, we don't think it would have been reasonable to expect my client to have been actively seeking legal advice at the time that DeMaio came out in 2018. I mean, I would agree that that's kind of the starting point, because that's the point.
That is a lot closer than the agency did, correct?
Oh, certainly.
All right.
Yeah, yes. I mean, the agency was expecting him to be consulting with an attorney practically from the moment he returned to Jamaica. And we think that's certainly not correct.
I thought it was pretty clear. The agency accepted your representation that the relevant time period was between DeMaio in April of 2018 and then in whenever it was June or whatever of 2019 when you filed.
Well, yeah. I think the board has some language going both ways, but we think the correct starting point is when DeMaio was issued. But we think when DeMaio was issued, it was not reasonable to expect my client to be seeking legal advice. We think it's only reasonable to expect him to do anything once he learned that there was something that he could even potentially file, by which point was June 2019, and then he did file within 30 days after that. Now, if the court has any concerns that ruling for my client would open the floodgates to all sorts of equitable tolling claims, I think that concern is unfounded for a number of reasons. First, equitable tolling requires, of course, both a showing of reasonable diligence and extraordinary circumstances. And between those two requirements, we think extraordinary circumstances is the more logical and effective gatekeeper, especially in cases involving changes in law. Now, we think we could satisfy the extraordinary circumstances requirement in this case.
But that's still up for grabs.
That's still up for grabs. Yes, the board never reached that, but given how unusual it is for Congress to pass unconstitutional statutes, we think we could satisfy that. But second, even when aliens do satisfy the equitable tolling requirements, they also have to satisfy the separate requirements for a motion to reopen and a motion to reconsider, both of which can be denied in the exercise of discretion. Now, again, we think we would have a strong argument on that front because there's no dispute that my client's conviction is not an aggravated felony. And the immigration judge originally found that he did merit a favorable exercise of discretion in connection with his cancellation application. And just finally, to the extent that the court might believe that ruling for my client would simply, I see that I'm out of time.
You can finish.
Yes. Will simply allow too many wrongfully deported aliens to return to the United States. I mean, we would think that is not a valid concern because if an alien should not have been deported in the first place, we think it would not be the role of the courts to deny his claim simply because it might lead to the granting of claims of similarly situated aliens.
Just hold on a second.
Yes.
Thank you very much. We're happy to hear from you.
Hi. May it please the court, Lindsay Dunn on behalf of the respondent. I do want to begin by clarifying a bit of what has been discussed that's been agreed upon or that the parties agree upon. There is this issue in terms of Mr. Williams being charged as deportable in terms of the aggravated felony charge, but he also was found deportable based upon a conviction involving moral turpitude. And the parties agree that that was never, that any challenge to that has never been exhausted before the board. So in other words, the IJ found that it was never brought up in the counseled motion for affirmance that was filed. Initially, it was never brought up in the motion to reopen that was counseled. It wasn't brought up in the subsequent petition for review that petitioner did file pro se before this court. And it also was not brought up in the last motion to reopen that we're discussing today. So there is that outlying ground of removability that simply has not been exhausted before the agency. Turning
Do you,
to,
do you agree with counsel's representation that his crime no longer qualifies under the law?
in terms of the aggravated felony, which is which was a separate ground of removal, I do note the agency never addressed that. So it hasn't been something that the government has contested.
So the government agrees. It doesn't contest.
Again, I'm not trying to make it any more difficult for the court than necessary, but I will concede that it was not the ground that this motion to be considered was denied on.
Okay.
It just wasn't reached.
Well, if we send the case back, what's your position going to be about the aggravated felon issue?
That would be a position that the DHS would have to come up with.
Which you follow Supreme Court law?
Absolutely. So, Your Honors, turning quickly to the issue in terms of how the court is going to review or what the standard of review should be in this case. I do want to note that the parties, as opposing counsel mentioned, the parties agree that Guerrero left open this question as to what the standard of review would be. But the government does note that Galvin, which opposing counsel raised, reviews a hardship determination for purposes of cancellation of removal. And that was previously unreviewable as discretionary. This is different in this case because, as this court has done in Lawrence, abuse of discretion has been the standard that's been applied in these types of cases. So Lawrence is a good example here because for another reason, the court first looked de novo, can we look at the diligence inquiry, but then was clear when it got to the merits of the diligence inquiry, applied abuse of discretion. And that's consistent with also what the Fifth Circuit did when Guerrero was sent back. It applied abuse of discretion. It has since applied this abuse of discretion in this context. And also opposing counsel did, in a 28J letter, send in a 10th Circuit case for Due v. Garland. That's 13 F 4th 1125. And we note that the 10th Circuit too, when looking at equitable tolling, is applying abuse of discretion. So applying abuse of discretion would be not only consistent with what this court has done when it has looked at the diligence inquiry, but it's also would be consistent with the 10th and the 5th Circuits. So just wanted to clarify that.
We do have a long line of cases that hold that the ultimate application of facts to the legal standard is a legal inquiry. My first question, and some of those cases are exceptional hardship in Galvin v. Garland, Whitaker case, government acquiescence in torture, in another case, good faith marriage. We've said that is a legal inquiry. Why shouldn't that be the case here?
Again, the government notes that those are different types of inquiries, and where, as in here, this court has looked at abuse of discretion in the context of tolling, it has first determined, can we look at the question, and that becomes a legal inquiry, but then it is reverted back to abuse of discretion. We're simply asking the court to be consistent with what it has done. And again, I specifically point to Lawrence. That's exactly what happened there. And so we're asking the court to again, be consistent. With respect to then looking at this in terms of the merits, and again, although the government is arguing that the standard should be abuse of discretion, whether it's abuse of discretion or de novo, the government argues that here, the petitioner, Mr. Williams, simply just did not show that he acted as a reasonable person should in this circumstance. I do want to point the court to the bottom of page 4 through the top of page 5 in the record, because here the agency makes clear that it is looking at that period after DiMaia is issued. The agency says that petitioner claims that only after the Supreme Court's holding in DiMaia would such a motion demonstrate an error of law that would support reconsideration of the board's decision. Assuming this analysis is correct, the circumstances presented by the respondent do not show that he pursued his motion with due diligence after the Supreme Court's holding in Sessions v. DiMaia. That's sort of at the beginning of the agency's analysis, and then the analysis goes from there. There are points within the agency's decision when it does refer generally to the whole period, but it's very clear when one reads this closely that the agency is assuming that the period is starting at DiMaia in 2018 and saying, essentially, you didn't show any diligence, or you didn't show the requisite diligence that we're requiring here. And so, again, I wanted to clarify the time period because that's relevant for the merits of the equitable tolling, but also the argument that petitioner is making with respect to sua sponte. So again, the time period, if it starts at DiMaia, the agency is saying here that consistent with what is in the declarations and what petitioner's counsel argued in the motion, petitioner just simply didn't show the requisite diligence in that period. Petitioner represented that he had been with his significant other since 2007. She came to Jamaica, they married in January of 2019. 3 months after that, she sought counsel to see if there was a possibility if her husband could return. And then only after that do we see petitioner making any efforts with respect to his claim. And really what the board is saying here is, in the past, you've had pro bono counsel. You've not made, or you've not in any way shown that there was any diligence that was, pardon me, the court, the argument here is that no diligence was shown during this period. Nothing can be pointed to. It's different than a situation like Lawrence, where Lawrence is arguing that from the moment he set foot in Jamaica, or the entirety of that period, he was at least trying to contact counsel, trying to do something. Here, if one looks specifically at the motion itself, at the declarations, there's just nothing that's been represented that was done in that full year period after DiMaia was issued. And the board determined that simply wasn't reasonable.
What if you had the same facts, but in fact, his, with this exception, in other words, there hasn't been a daily look at SCOTUS blog or anything else. So we don't have a day by day consideration by the claimant, but the claimant is significant other goes to a lawyer 2 months after and they find it. Would that be adequate?
Again, it's case by case, but that's the court didn't just look at timeliness. There's a
well, that's what I sort of don't understand, so that you have to know the moment it comes out. There must be some time that it is part of the limitation.
I don't think that the board is saying that you have to know the moment that it came out. The board is making the argument that in this entire period, the record is silent to any sort of diligence being shown.
I understand.
It's not as though, pardon me, I'm sorry, if the delay is, let me pause.
All I'm asking you is if the delay was 2 months and there was no efforts during that 2 months, would that down the case too?
I think that puts one in a different circumstance in terms of the timing, yes. But really, again, the board is looking at, there's an entire year where nothing is done. So it's not only that it's not discovered, it's that nothing is done. And this person has had pro bono counsel in the past and has shown that his wife has the ability to contact counsel on his behalf in the United States where she lives. Nevertheless, there's this entire year where nothing is done.
I understand that I think it's 9 months, but we'll go with your entire year right now. But what I'm asking you is, what if just 2 months, same facts otherwise, he doesn't do anything for 2 months, but then he files?
Your Honor, I would view that differently. I do think that's a different, we're giving a different time frame here. I don't think, again, that the board is saying that he had to do something the moment that the case came out. It's that he didn't show reasonable diligence by doing nothing for that extended period after.
And what I'm trying to do is to piece out from that what somebody in the future could conclude would be reasonable diligence. And you won't seem to answer, so I suggested, would 2 months be reasonable diligence?
I would think so if some sort of diligence were shown.
In 2 months?
Yes. But again, unfortunately, that simply just was not the case here. I do want to also address counsel's argument in briefing that the court should find jurisdiction to look at this in terms of the sua sponte denial. And again, just point the court to the actual decision in the record. Here, counsel's arguing that the court should upend its previous precedent and look at this sua sponte denial based on error. And no error has been shown here with respect to the agency decision. Counsel's basing this on 2 points. One, the citation of matter of GLC for the proposition that it may consider non-citizens' diligence in deciding whether to sua sponte reopen. The government, again, reasserts that this was an accurate discussion of what happened in matter of GLC. And also, the government makes this critical note that unlike in cases in other jurisdictions where the court has decided to pierce this and look at the sua sponte denial, here, there's no material error here that would change the decision. And I'll look at a case like Mahmoud v. Holder in the Second Circuit, where the court basically declined to exercise sua sponte authority based on its understanding that the petitioner would automatically be barred from seeking adjustment. Here, there's nothing like that. Our petitioner doesn't point to anything in that regard. There's nothing that petitioner can point to that suggests that the agency can't look at diligence when it's examining sua sponte, as it did here. And it's consistent with what the agency has done in other cases. There's simply just nothing prohibiting the board from doing what it did, whether it were to cite that case or not. And the second note, petitioner again is arguing that with respect to the sua sponte assessment, that the court is looking at the time frame of, beginning when petitioner was removed to Jamaica until the time that he filed. And I do point the court to the language in the record at AR5. The board specifically says that it's referring to its discussion above. I mean, that last paragraph, the court says, as discussed above, the respondent has not satisfactorily explained his lack of diligence. The court discusses the court refers to the 12-year period, but the entire analysis is framed above, and the analysis that the board is referred to by that period after DiMaia. So there's no error there, and petitioner really does not there's no reason why the court would stray from what it has done in the past in terms of not looking at the sua sponte denial. And again, that's also consistent with what the court has said in Lawrence. And I point the court to footnote 5 in Lawrence, where the court here again explains that where there's no perceived legal error, this is just not something the court is going to do.
Ms. Dunn, let me ask you this. After he found out about DiMaia, was he diligent?
The record does show that steps were taken to file something, but again, that's months and months after DiMaia has been decided, where in that period before nothing was done.
Well,
and that's what the board's looking at here.
That he was diligent after he found out about DiMaia. Shouldn't that weigh in our analysis?
Not in terms of how the court has looked at this in the past. And I will note that while the court has, in this case, looked at the entire period after DiMaia, in Lawrence, the court has said that it's up to the petitioner to show diligence during the entire period. And that includes diligence in discovering that there is a change in law. And I'll point the court there to Lawrence at 826 F3rd at 204 through 205. And there, the court is upholding a decision, and the board had in that decision cited Rashid v. Mukoski at 533 F3rd 127. That's a Second Circuit case, but explains that again, it's the petitioner has to show some sort of effort. Even if the discovery isn't made, the petitioner has to show that there was some diligence in trying to make the discovery. Here, as in that case, there's just nothing that showed during that period. And the board was correct in determining that simply is not reasonable.
Don't think we have any more questions.
Thank you very much. Again, the government reasserts all of the arguments made in its briefing, and thanks the court.
Thank you very much. Do we have any rebuttal?
Yes, thank you, Your Honor. If I could just tie up a few loose ends on equitable tolling before moving to the sua sponte argument. Just to clarify.
Tell me what the difference is between the two, because the reason why you think that the sua sponte should have been granted is because wasn't there a legal error, and the legal error, it goes back to the equitable tolling, doesn't it? So aren't they sort of two sides of the same coin?
They're similar but distinct. The equitable tolling argument simply, if equitable tolling is granted, then the board would be applying just the regular baseline standard for a motion to reconsider, which is whether there has been a change in law. To prevail on a sua sponte motion, you have to show that the change in law was fundamental. So there is a different standard that the board applies. Just to clarify the relationship history between my client and his now wife, they actually first got together in 1997, and they did have children together in 1999 and 2002. But in the following decade, my client had 2 children with another woman. She had 2 children with another man. She did eventually visit him in Jamaica after he was deported, but they did not officially marry until January of 2019, which is why she went to see an immigration attorney in April of 2019. So the point is simply that while the board didn't say anything that was literally false in its decision kind of misleadingly suggests that my client and his wife have been married for decades, which simply is not the case. Now, on the merits, there was some discussion about, would 2 months be an appropriate limit?
Before we get to
Yes.
that, can I ask you about the standard of review?
Yeah.
The government points us to Lawrence, which I think is correct. Lawrence applied abuse of discretion. And so I think the question for us is, does Guerrero require us to overrule our precedent? Is it on point and clear enough that we can overrule Lawrence? Or what's your position on that relationship?
Well, that's a question I've grappled with, but I think Lawrence actually, I think any discussion of abuse of discretion was dicta, because there was only the only question before the court in Lawrence was whether the board even applied the correct standard. Because at that time, this court regarded the due diligence determination as a factual inquiry that it did not even have jurisdiction to reach.
Be dicta? It's the lens through which the court is reviewing the claim. Even if you think, well, ultimately they would have won or lost under a different standard, the court says we're applying a certain standard. How can that be dicta?
Well, my point is the court did not have jurisdiction to actually reach the merits of the equitable tolling claim in Lawrence, because Lawrence was decided before Guerrero-Las Fria. I think there's frankly conflicting case law on what standard should be applied to equitable tolling, because there are many other cases, including Rouse, that have applied de novo to the ultimate diligence
But we
determination.
have case law applying abuse of discretion to equitable tolling before the BIA, exactly this context. And so you have the burden to show that we need to change our precedent, and not just that we need to, but as a panel of three that we're even allowed to. And the only way you can do that is by pointing to something the Supreme Court or Congress has done that requires us to overrule what a previous panel has done. Otherwise, we have to sit en banc. So what requires us to change that?
We think Guerrero-Las Fria would be sufficiently clear, because before Guerrero-Las Fria,
but it didn't talk. They specifically reserved the question of what standard of review applies, which indicates there could be multiple different ones that might be appropriate.
That's true. But in Galvan, this court found, because of Guerrero-Las Fria, not only that it had jurisdiction,
right,
but that it would apply de novo review to the ultimate question.
That's right.
But
that's in a situation where we didn't have any precedent about what standard of review applied, because we had previously refused to consider those questions.
At the end of the day, Your Honor, we think we win even under abuse of discretion, because it's clear that when an agency errs as a matter of law, that is an abuse of discretion.
Sure. Thank you.
Okay. So just on the question of, if there is a rule, 2 months, what is it? Our point is that the only way that an alien could to guarantee that an alien would act within 2 months, pardon me, is if they are having consultations with an attorney on a regular basis. That's the only way to guarantee that. So if the court finds that my client did not act with sufficient diligence, immigration lawyers will have to advise their clients going forward, even after they're deported, that they need to schedule regular consultations with them. So we would ask the court, if it denies our claim on the merits, to at least provide some guidance to the immigration bar as to how frequent is enough. Does it have to be once a year? Does it need to be every 6 months? Does it need to be once per month? Because the immigration bar will need to provide guidance to their clients in the event that they are deported, should they ever want to try to file a motion based on a change in law.
Can diligence take other forms? I know here we're talking about checking in with the attorney, because that's what he did. That's the diligence that he presented to the BIA, was my wife checked with an attorney. Mm-hmm. But presumably diligence can take other forms, right? He could have, I don't know what your particular client could have done, but in any future case, there could be someone who says, I don't know, I checked the newspaper, or I looked here, I looked there, places that may or may not have the answer, right? The question is not whether they would have found it, but whether they were diligent in trying, right? So I take your point, but I'm not sure we have to set out a framework for immigration attorneys, because diligence is as vast and broad as there are different kinds of cases.
Sure. I think in the context of a change in law, or where the Supreme Court is overruling decision is unconstitutional, it's hard to imagine a circumstance where a layperson would be able to piece that all together without talking to an attorney. Although if perhaps if a deported person was previously a paralegal, they might be able to do that. But I think in general, that would be difficult for them to do. In my time left, just briefly on the reviewability of the sua sponte question, we would ask to join the 7 other circuits that have held that they are able to reach asserted legal errors made in connection with the denial of a sua sponte motion. And we think the reason is very straightforward. the Supreme Court has held that there is a strong presumption favoring judicial review of administrative action, and that the exception in section 701A2 only applies when there is no judicially manageable standard. So it follows that when the board alleges that the board has committed legal error in denying a sua sponte motion, there is a judicially manageable standard that courts can apply.
That doesn't help you, does it? Because all the other courts that you cite, they've done this when the BIA thought it lacked the power, or it had some sort of misperception about the legal background. It was something pretty fundamental. It was not, we think that it reached the wrong decision about equitable tolling. No one has reviewed that de novo.
I'm talking about simply an asserted legal error, a question of law. And as I read those cases, those courts have held that they can review questions of law raised in challenging a sua sponte motion, just as they can review questions of law raised in challenging in a petition for review on direct appeal. Many, if not most courts that have addressed this issue in our favor have made an analogy to section 1252A2D of the INA. That's provision that authorizes courts to review questions of law. And we think that would be the most administrable line, if the court agrees with our position, to say, just as we can review questions of law and constitutional claims on a regular petition for review, so can we review constitutional claims and questions of law raised in connection with the denial of a sua sponte motion. If the court has no, yes.
So, excuse me, just so I understand, in response to my colleague's question, you concede that none of those out-of-circuit cases that you cite deal with the question of law that we have here, but they all deal with questions of law, which you think this is. Is that right?
Correct.
We have further questions? No. Thank you very much. We appreciate the argument from both counsel, and we're sorry that we're not able to come down and shake hands. We can do it remotely. And we hope the next time you're here, we will be able to do so. So I ask the clerk to adjourn court.
This honorable court stands adjourned until this afternoon at 2 p.m. God save the United States and this honorable court.